I would like to ask HM Attorney General if he will make a statement on the gestation of the Music and Dancing Act 1961, with special reference to the provisions setting out exemptions from the Act, what purposes such exemptions service, where and to whom they apply, and when such provisions were first introduced into Manx law.
Calling the learned attorney.
Thank you, Mr. President. The Music and Dancing Act 1961, the 1961 Act, was introduced to update and consolidate the law on the licensing of places used for public music, singing and dancing. Before the 1961 Act came into operation, the existing law in this area was the Licensing Music and Dancing Act 1912, the 1912 Act, later supplemented by the Licensing Music and Dancing Act 1927. Under the 1912 Act, places, whether or not licensed to sell alcohol, could not be kept or used for public dancing, singing, music or other public entertainment of like kind without a license. And the license could not permit such places to operate between the hours of 11 p.m. and 7 a.m. The issue had been debated at least as far back as 1895, when a bill to regulate public places of music and dancing was considered. The bill had proposed to restrict the opening of such places of entertainment to the hours prescribed for premises licensed to sell alcohol, but it was realised that such would make sacred concerts on Sundays illegal. By Section 15 of the 1912 Act, the licence requirement did not apply to places kept or used for public dancing, singing, music or other public entertainment of like kind for philanthropic, charitable or religious purposes, or obtaining funds for the same. By 1960, it was felt desirable to update the 1912 Act. There were two statutory conditions to the granting of licences in the 1961 Act, as originally enacted. A licence could not be granted in any room in premises licensed for the sale or consumption of alcohol later than the hours or times during which alcohol could be sold or consumed, and where licensed premises contained two or more rooms used exclusively or mainly for the sale or consumption of alcohol. One of those rooms could not be licensed under the 1961 Act. These conditions have since been removed following amendments to the law on licensing of alcohol. With respect to the exemptions from the licensing requirements in the 1961 Act, Section 20 of that Act preserved Section 15 of the 1912 Act, substantially unchanged, so that the exemptions in place today are very much those enacted in 1912. The 1961 Act has been amended subsequently by, amongst others, the Licensing Amendment Act 1986 and the Licensing Act 1985. The 1986 Act permitted a licence for music to be endorsed on a liquor licence, and the 1995 Act developed this further and permitted a liquor licence to include authorisation for music and dancing so as to avoid separate applications. The 1995 Act also exempted licensed premises and club premises, within the meaning of that Act, from the 1961 Act, as such premises are now regulated under the Licence Act 1995 with respect to music and dancing. The exemptions under the 1961 Act mean that a requirement to obtain a licence under the Act do not apply to any place used for entertainment purposes, for philanthropic, charitable or religious purposes, or for obtaining funds for the same. Thank you, Mr. President.
Supplementary, Mr. Moorhouse.
Thank you, Mr. President, and thank you, Mr. Attorney, for such a detailed answer, and possibly going further into what you said, sir. Can the Attorney General confirm that if an individual or organisation was to arrange a public fundraising event for charitable purposes such as hospice within a private house or private gardens, where the event includes music and or dancing, no licence is required due to the exemption criteria provided within the 1961 Act?
Mr. Attorney.
Mr. President, I believe that the exemptions which I've read out from the 1961 Act make that abundantly clear, that a licence would not be required.